If you entered the United States on ESTA, fell in love, married a U.S. citizen, and you're thinking, perfect, I'll just go to my marriage-based green card interview and walk out with an approval, I need you to listen very carefully. In the current enforcement climate, especially looking ahead to 2026, that green card interview can turn into the day you are walked out of the building and put on a plane. And you might not even get the chance to see an immigration judge, hire a lawyer, or fight for your case. A lot of people hear visa waiver program and think it's just a convenient way to travel. No consulate visit, no long interview line, no thick stack of documents, no visa foil in the passport. You fill out the ESTA form online, you get an authorization, you board the plane, and you're in. It feels easy, it feels friendly, it feels like the US is treating you as a low-risk traveler. And for millions of people, that's exactly how it plays out. But here's what most people don't really understand. That word waiver in visa waiver program is doing a lot of work. You are not only waiving the requirement to get a visa before you travel. In many situations, you are also waiving rights that normal visa holders would have if the US government later decides it wants you out of the country. That's the part that can turn a routine marriage interview into a life-changing enforcement event. To make this clearer, I want you to imagine two people. We'll call one Elvis and the other Victor. Elvis enters the United States using ESTA under the visa waiver program. Victor enters the United States using a traditional non-immigrant visa, like a B1, B2 visitor visa, or maybe an F1 student visa. Both are inspected at the airport. Both are admitted lawfully. At the moment they enter, they are both here legally. Now both Elvis and Victor meet a U.S. citizen, fall in love, and get married. They both decide they want to apply for a marriage-based green card from inside the United States. They look online and see that spouses of U.S. citizens are immediate relatives, which is the strongest family category. They think, we're married, our relationship is real, what could go wrong? Here's what can go wrong. The process, the protections, and the risks are not the same for Elvis and Victor, and the difference can be life-changing. When you enter on ESTA, you are typically admitted for up to 90 days. That's it. There is no extension of stay and there is no change of status within that program. The government's expectation is that you are coming temporarily, you are leaving quickly, and you are not using that short visit to turn yourself into a permanent resident. Now, does that mean nobody ever adjusts status from ESTA? No. People do it all the time. Immediate relatives of U.S. citizens can often file for adjustment of status even after an overstay, and many of those cases get approved. But the real issue is not just, am I allowed to file? The real issue is, what happens if the government doesn't like something about my case? And what tools does the government have if they decide to enforce the rules in the harshest way? Because here's the critical legal reality about the visa waiver program. As part of entering on ESTA, you generally agree that if the Department of Homeland Security decides you are removable, you are giving up the normal right to fight your removal in front of an immigration judge, with only very limited exceptions. You're saying, in writing, if they decide I have to go, I will go without the usual court hearing. Most traditional visa holders, like Victor, if the government wants to remove them, are placed into removal proceedings. They get a notice to appear, they get a court date, they stand in front of an immigration judge, they can ask for time, they can ask for bond, they can have a lawyer argue that they qualify for relief, or that they should be allowed to finish a pending marriage case. A neutral decision-maker, the judge, decides what happens next. That's Victor's world. Elvis's world can look very different. If DHS decides Elvis is removable, they can move quickly. The normal path to a judge often just isn't there in the same way. That's why, here at Immigration Newsroom, we're talking about this so urgently, because we are seeing more aggressive enforcement behavior in some situations, including cases where someone shows up to what they think is just a paperwork appointment, and that same appointment becomes the moment when enforcement is triggered. So let's walk through how this can play out in real life. Elvis enters on ESTA, admitted for 90 days. He meets his U.S. citizen partner, they get married. They decide to file the full marriage package, the I-130 petition and the I-485 adjustment application, maybe while he's still inside that 90-day window, maybe shortly after it expires. Their marriage is real. They have photos, joint bank accounts, leases, all the evidence. On paper, it looks like a case that should be approved. But when Elvis goes to his interview, USCIS is under no obligation to approve that case on the spot. The officer can keep the case open. They can issue a request for evidence. They can separate the couple and question them individually. They can dig into intent issues, what Elvis was planning at the time he entered on ESTA. They can suspect fraud even if there is no fraud. They can decide there's a misrepresentation problem. They can pull up old records from previous entries. They can decide the marriage evidence is weak, the medical exam is incomplete, a prior overstay raises concerns, or a previous visit suggests immigrant intent. And if, at the end of all that, USCIS decides not to approve and DHS decides to take enforcement action, Elvis may not have the same long procedural runway Victor has. Victor can absolutely have problems at his interview too. He can be denied, he can be arrested, he can be placed into removal proceedings. But once Victor is in removal court, he usually has something Elvis does not, a built-in process where the government issues formal charges and then a judge, not just an officer, gets involved. Victor can request a bond hearing in many cases. Victor's lawyer can ask the judge for time, can keep the case alive while the I-130 petition is pending or after it's approved, and can argue that Victor deserves discretion. It's stressful and scary, but there is a sequence of steps and a neutral referee. Elvis, as an ESTA entrant, may be treated like someone who already agreed that if DHS wants him out, he goes without that full court process. Once DHS is in that mindset, they can move quickly. That's the nightmare scenario. You attend what you think is a routine marriage interview, and instead it becomes an enforcement event. And by the time your family is calling lawyers, you're already detained or even on your way out of the country. Now, to be completely fair, plenty of people who entered on ESTA have adjusted status and everything turned out fine. We see that all the time. The point of this video is not every ESTA adjustment case ends badly. The point is that when an ESTA case goes wrong, it can go wrong faster and with fewer guardrails than a typical visa holder case. And as we move into 2026 and beyond, in a stricter enforcement climate, that risk calculation is changing. So what exactly is the danger moment? It's not the marriage itself. It's not even just filing the forms. The real danger moment is when you put yourself physically in a government building where the officer has both the information and the opportunity to act quickly. The marriage-based interview is exactly such a moment. You're sitting in a federal office. You're fingerprinted. Your whole immigration history is on the officer's screen. If they decide you are removable and ICE is available and willing to act, they can move immediately. If you're Victor, the visa holder, and something goes wrong, the most common outcome is that you're placed into removal proceedings where you still have a chance to ask a judge for time to pursue your green card, or to ask for bond, or to present your side of the story. If you're Elvis, the ESTA entrant, the government can decide the case is over and you may not have that same opportunity to slow things down. Now we need to talk about what happens after removal, because a lot of people don't understand how one bad day can turn into years of separation. There are different reentry bars that can apply depending on your history, and the details really matter. One big set of penalties comes from unlawful presence. If you accumulate more than 180 days but less than 1 year of unlawful presence, and then you leave the United States, you can trigger a 3-year bar. If you accumulate 1 year or more of unlawful presence and then leave, you can trigger a 10-year bar. Those bars usually activate when you depart. On top of that, there are separate penalties when the government actually removes you, especially if it's done through a fast-track process or if they allege fraud or misrepresentation. Some types of removal carry their own multi-year bars. The point is not to memorize numbers. The point is to understand that once DHS removes you, rather than you leaving on your own schedule, you can be facing serious reentry consequences layered on top of unlawful presence issues. What you thought was going to be a straightforward marriage case can suddenly become a long-term separation with complex waivers and a difficult fight ahead. That's why you need to stop thinking of ESTA as just another visitor entry. You need to start thinking of ESTA as a visitor entry where I gave up a major procedural protection if the government later decides to remove me. Timing and intent are another big source of confusion. Couples meet, fall in love, get engaged quickly. That's life. The law does not say you can't fall in love during a trip. It doesn't say you can't get married after you enter. What the government cares about is what your intent was when you entered. If someone comes in on ESTA saying, "I'm just visiting," but in reality they already plan to stay permanently and file for a green card, that can be treated as a misrepresentation at the border. That's a separate legal problem that can make you inadmissible and can require a difficult waiver. Intent is tricky because it's about what was in your mind at the time of entry. USCIS and consular officers often infer intent from your timeline and your behavior. Did you have a return ticket? Did you quit your job back home? Did you ship your belongings? Did you tell friends and family you were moving to the US? Were you already engaged, or did you have a wedding date set before you traveled? Did you start house hunting or enrolling kids in school immediately after arrival? So when Elvis enters on ESTA, marries quickly and files quickly, USCIS may start asking, was this really a spontaneous decision, or was the plan always to come, marry, and stay? Many legitimate couples can answer those questions honestly in a way that shows the relationship developed naturally after entry. But the shorter and tighter that timeline is, the more scrutiny you should expect, and the more important it becomes to get competent legal advice before filing. Victor can have intent issues too. If he enters on a visitor visa intending to live here permanently, he can run into similar accusations of misrepresentation. But again, Victor usually has stronger procedural protections if the government challenges him. So what should you actually do with all of this information? If you are overseas right now and thinking, I'll just use ESTA to fly in, marry my US citizen fiancé, and then stay and file for a green card, you need to slow down. I'm not saying it's impossible. I'm saying you should not treat it as a casual travel plan. You're making a legal decision with serious long-term consequences, and you need individualized legal advice before you take that step. If you are already in the United States on ESTA and you're married to a US citizen, you need to understand that your strategy matters. Whether you file for adjustment now or not, whether you wait, how strong your evidence is, what your previous immigration history looks like, prior trips, prior overstays, prior denials, any arrests, any past misrepresentations, all of that will shape your risk. A clean, well-documented case with a long-term relationship and no red flags is very different from a messy case with missing evidence, inconsistent timelines, or prior immigration problems. You also need to think seriously about whether consular processing might actually be safer in your situation. Consular processing means you file the I-130, you get it approved, and then you finish the immigrant visa process at the US consulate in your home country. You then enter the United States for the first time as a lawful permanent resident. Emotionally, that can be harder because it often requires a period of separation while the foreign spouse is abroad. But from a risk management perspective, there are situations where consular processing is the safer path, especially if staying in the US, and filing adjustment could put you in a position where a denial leads straight to a fast removal. Of course, many people are afraid to leave because they worry about triggering the 3-year or 10-year bar. That's exactly why this is not a one-size-fits-all situation. Sometimes people stay and file in the US because leaving would activate a bar. Sometimes, staying and filing with a high enforcement risk is actually worse than leaving and dealing with the bar through a waiver. You have to compare those risks honestly, not just emotionally, and that's something you really should do with a qualified immigration lawyer, not based on stories from friends or strangers online. There's another big misunderstanding. People think that simply filing for a green card protects them from enforcement. They see the receipt notice and think, okay, now I'm safe. In practice, having a pending case can sometimes help because it shows you have a legal pathway and are trying to follow the rules. But the filing itself is not a magic shield. It doesn't change the way you entered the country. It doesn't undo the rights you waived under ESTA. It doesn't automatically stop DHS from taking enforcement action if they choose to. So imagine 2 interview days. One for Victor and one for Elvis. Victor walks into his marriage interview. The officer asks questions, looks at photos, reviews documents. Maybe the officer is convinced and the case is approved. Fantastic. Maybe the officer isn't convinced and the case is denied. Victor can still often be placed into removal proceedings, where his lawyer asks the judge for time, argues that the marriage is real, tries to fix whatever the officer didn't like. It's stressful, but there is a structured legal process with multiple steps. Now Elvis walks into his marriage interview. Same questions, same documents. But if the officer decides not to approve and flags Elvis as removable, Elvis might not simply walk out with a denial letter and a future court date. He might be detained on the spot. He might be transferred to ICE custody. He may be scheduled for rapid removal under the terms of the visa waiver program. His spouse may be outside the building, waiting for good news, and instead get a phone call saying he's been taken into custody. That can all unfold in hours. Sometimes a lawyer can step in quickly and file an emergency habeas petition in federal court, asking a judge to stop the removal and review what happened. But that is extraordinary litigation, expensive, rushed, and highly dependent on timing, facts, and jurisdiction. It's not a simple fix. And no honest attorney can promise you that a federal judge will jump in and save the day before DHS executes a removal order. The best approach is to avoid ever needing that kind of emergency rescue in the first place. If you're a U.S. citizen married to someone who entered on ESTA, you need to understand that your spouse may be far more vulnerable than you realize. That vulnerability is not about whether your love is genuine. It is about the procedural protections they waived when they came in under the visa waiver program. If you are the immigrant spouse, you need to understand that ESTA may have felt like the easy way in, but once something goes wrong, it can become the fastest way out. If you're still outside the country, planning to use ESTA as your shortcut into a marriage green card, treat that as a serious legal decision, not just a travel convenience. The difference between entering on a full visa and entering on ESTA can be the difference between, if something goes wrong, I fight in court, and, if something goes wrong, I might be gone before I even understand what happened. None of this is meant to scare you into doing nothing. Doing nothing, overstaying, never filing, never asking questions, is often the worst plan. The goal here at Immigration Newsroom is not fear, it's informed decision-making. Sometimes the right move truly is to file adjustment of status inside the U.S. with a carefully prepared package, strong evidence, and a clear explanation of your relationship timeline. Sometimes the right move is consular processing, especially when there are prior violations or risk factors that might make a denial inside the U.S. much more dangerous. Whatever your situation is, get personalized advice before you act. Don't rely on what worked for a friend or a random person in a Facebook group. Don't assume that filing alone will protect you. Understand how you entered, what you signed, what you waived, and what could realistically happen at that interview. If this breakdown was helpful, make sure you subscribe to Immigration Newsroom, turn on notifications so you don't miss future updates, and share this video with anyone thinking about marrying a U.S. citizen after entering on ESTA. Tell me in the comments where you're watching from, and what part of your situation worries you the most. Your questions help us decide what to cover next. Thank you for spending this time with me on Immigration Newsroom. Stay informed, stay cautious, and stay hopeful. And remember, when it comes to your immigration future, understanding the risks is the first step to protecting the people you love.